Carrying in the appeal, Whitlock and another, and Moree.
Yes, Mr. King.
My lady, my lords. As you know, I appear with Mr. Goodcamp for the appellants, Mr. Whitlock and Mrs. Jack. My learned friends, Mr. Parker and Miss Quant, appear for the respondent, Mr. Moree. My lady, you will have had a very detailed case from me, and no doubt...
We've had very detailed cases from both of you.
I didn't mean to exclude Mr. Parker's case.
And you can take it for granted that we have read them.
I'm grateful, my lady. Well, what your ladyship knows is that this appeal is about whether the Court of Appeal of the Bahamas was justified in interfering with the critical finding of fact made in this case by the Chief Justice of the Bahamas, Sir Michael Barnett. The Chief Justice found as a fact that it was more likely than not that Mr. Leonard had not intended to make a gift to Mr. Moree of the monies in his bank accounts at the First Caribbean International Bank Limited, when Mr. Moree was added as a signatory to those accounts on the 20th of November 2009. All the monies in those accounts had been deposited by and were Mr. Leonard's. It's common ground, my lady, my lords, that a joinder, or the joinder of Mr. Moree to those accounts, gave rise to a factual presumption, which the law makes in those circumstances, that Mr. Leonard did not intend to make a gift of those monies to Mr. Moree. Unless rebutted, that presumption in turn gives rise to a resulting trust, by which, in this case, Mr. Moree held the legal estate in those monies, or more accurately, in fact, in the shows as in action against the bank in respect of those monies, on trust for Mr. Leonard and upon his death for his estate. The presumption is, however, as one knows, always rebuttable. The burden of proof...
Is your case that that clause 20 of the document is relevant only as evidence of intention?
Yes.
Or is it your case that it is legally conclusive simply by virtue of being the nature of the arrangement between the creditor and the bank?
Our case is that it is a factor to be taken into account, which may, in the evaluative exercise of a tribunal, be taken into account in ascertaining what the intention was of Mr. Moree, whose accounts they were originally, and to which Mr. Leonard, whose accounts they were originally, and to which Mr. Moree was joined. They form a contract, as a matter of law, between the applicants and the bank. And if one traverses the Commonwealth authorities from Canada and Australia, what one finds is that the courts there, including the Supreme Court of Canada and the High Court of Australia, the courts there regard banking documents as by no means conclusive, but they regard banking documents and what they contain as potentially relevant to the ascertainment of the intention of the parties to the documents.
And is that something that's implicit in their treatment of the case, or have they expressly addressed the question whether they might not be conclusive?
I'm not sure how detailed it is. If one goes to Peccary, for example, in the Supreme Court of Canada, and if you would forgive me, that is in bundle, that's in, I don't know how your lordships and my lady have those, but they're in my volume 2 of the authorities bundle, and they're at, it's at divider.
You should have them in the same way that we have them, or we should have them in the same way that you do, and most importantly of all, you should have the electronic bundle page.
I was going to take you to the tab, my lady, 28.
No.
Page 1149. Well, it begins at 1132.
Well, that's a different tab. That's tab 28.
And they both work.
Well,
doesn't always happen.
At least I've made a reasonable start to that extent. This is a Supreme Court of Canada. It's a 9-judge panel.
It always is.
Right, my lady, but there was only one dissentient. And the judgment was given by Mr. Justice Rothstein. And if you go, please, to page 1149, to paragraph 60 and 61.
What's the status of Canadian authorities in the Bahamas?
The Bahamas is a common law jurisdiction, my lady. It's also an equity law jurisdiction. And whilst they don't have any precedential status, my lady, obviously, just like any superior court from a Commonwealth jurisdiction, they will be influential and persuasive.
Is it the situation in the Bahamas that the default position, if it's not clear what Bahamian law is that it's the law of England and Wales? That's usually the constitutional position in Caribbean constitutions.
Certainly they look to the law of England and Wales. I don't know whether there is a constitutional provision or a statutory provision. I don't personally know, and I'll check in a moment, whether there's a statutory provision which says that in the absence of Bahamian law, it is the law of England and Wales which prevails.
I don't know the answer to that, but I think it would be a useful thing to know,
I'll
in
find
case
out.
there is any conflict between the English authorities and the Commonwealth authorities.
I mean, we would always look with interest at decisions of the Supreme Court of Canada to determine what English law was.
Of course we would, of course we would.
And what one finds in the judgments in this case, my lady, is that the judges cited from a number of authorities from a number of different jurisdictions, including England. And if you could have a look at paragraph 60 and 61, it's put, as you see from 60, in the past this court has held that bank documents that set up a joint account are an agreement between the account holders and the bank about legal title. They're not evidence of an agreement between the account holders as to beneficial title. See Niles, which is also a Canadian case, of course, and in re Mailman, also Canadian.
Have we got those cases?
We don't have those cases. We do have, my lord, an extract from Niles in one of the judgments, though.
Right. We probably ought to look at them.
And I'll take you to that in a minute. While I agree that bank documents do not necessarily set out equitable interests in joint accounts, banking documents in modern times may be detailed enough that they provide strong evidence of the intentions of the transferor regarding how the balance in the account should be treated on his or her death. Therefore, if there's anything in the bank documents that specifically suggests the transferor's intent regarding the beneficial interest in the account, I do not think that courts should be barred from considering it. Indeed, the clearer the evidence in the bank documents in question, the more weight that evidence should carry. So the position, as I understand it, in Canada is that the bank documents may be evidence or may be admissible evidence of intention, and obviously the clearer the bank documents are, the weightier the evidence is, and we would suggest that that is sensible as a matter of common sense. The problem that arises, I don't really want to, wasn't really intended to go down this avenue, but since Lord Sumption has asked me a question, the problem that arises, of course, is that the bank documents sometimes, like clause 20 in our case, are difficult to construe, even for lawyers, let alone for individuals who may be signing the documents themselves. And so what one is looking for in bank documents, if they are going to be of any value, is explicit reference to the entire and absolute ownership of the monies, or specifically, as the courts have repeatedly said, beneficial interest or the whole beneficial interest. This is slightly out of my path, but...
those two paragraphs that you read to us are very clear in themselves. Were they an issue in these proceedings as between you and the other side? No,
no, my lord. The legal principles have all been accepted. Yeah. There's no doubt but that in the Court of Appeal, there was an English case of Mr. Justice Lawrence Collins, as then he was, in Aroso and Coutts. And one can look at that case in a moment. And in fact, it's a useful case, not only for what it says, but also for the terms that were under consideration in that case, which may well have had a bearing, well, did have a bearing, upon the learned judge's attitude towards it. In relation to the law on banking documents, if I could just refer you to our case so that you know where it is set out in our in our case. You'll find it at paragraphs our legal principles start at page 550 of the electronic bundle. And if you turn to to paragraph 86, at page 563, you'll see where we address the question of the proper construction of clause 20 in these banking documents. My Lord, Lord Sumption asked me about Niles. If you go to, I'm sorry to jump around a little bit, but if you go to the Court of Appeal judgment, which is beginning at page 110.
Sorry, where is
And you go to paragraph 34.
Do you have a page number for that?
It's page 128, my Lord.
Yeah.
paragraph, sorry?
Paragraph 34, my Lord,
Yes.
in the Court of Appeals judgment at 128. Reference is made in Peccary, to Niles in Peccary. And here we see Mr. Justice Taschereau observing the words, shall be the sole property of the undersigned, or right of survivorship, and all monies in the joint account to be the joint property of the undersigned, are indeed apt words to convey a legal title to the fund, but not to convey the whole fund beneficially. Something more than a mere transfer is required to destroy the presumption of a resulting trust, and an intimation of such intent must appear in the document itself, or as a result of evidence which reveals the intention to benefit the transferee.
I mean, it looks from the description of Niles in the passage you just showed us from the Supreme Court of Canada like a case we ought to see.
Yeah.
Very well, my Lord.
And the other case mentioned as well.
Yes.
Because it looks as if, essentially, Justice Rothstein was basically taking a different line to the one which had previously been taken in Canada.
Well, the one that had previously been taken in Canada was very much that the banking documents were not conclusive at all,
Okay.
and they were merely, or constituted merely, an agreement.
Well, in that case, we clearly should see those cases.
Right, my Lord. But they constitute merely an agreement between the account holder and the bank, and not an agreement between the account holders
It's
inter se.
interesting that general observation by the Canadian Supreme Court in Pecor, said to be based on Niles, takes one back to Niles, where the relevant words say it's understood and agreed by the undersigned with each other and with the bank.
Yes. Yes.
And one wonders whether the Supreme Court in Pecor are just giving sort of expressing a view about a general starting point, subject to what any particular banking agreement may say. But they went out of their way in Niles to make it an agreement between the joint holders as well.
In that case, that seems to be right, my Lord.
I just wonder whether we can, how easy it is to accept a sort of invariable legal proposition that bank documents are always and only between the bank on the one hand and the joint owners on the other, and not between the joint owners.
I'm not actually necessarily putting forward that as a proposition that you should adopt. I have not taken the view, or rather the approach, that the banking documents may be, as it were, ignored because they don't constitute an agreement between Mr. Moree and Mr. Leonard. I'm saying, and all I'm saying, in relation to the bank documents, that they may contain evidence of actual intention of Mr. Leonard. The clearer the language, the more weight might be attached to the finding of an intention. And the less clear the language, the less useful they are. If I could just take you to Aroso, the Aroso and Coots case, my lord, which you'll find in our authorities bundles at divider 1 at page 618.
Sorry, page?
618.
Thank you.
The first matter that distinguishes this case appears from page 621, from paragraph 9. Which is that the bank official who dealt with the deceased was Mr. Horsley, a client relationship officer at the bank who spoke Portuguese and concentrated on clients who lived in Portugal. The second thing is in paragraph 11. Mr. Horsley had a meeting with the deceased, and his note of the meeting records that the deceased wished to change the signatories on the account. Mr. Horsley then gave evidence about how the process worked. And if you turn, before I go to the clauses in question in that case, to paragraph 21 at page 621. Could I invite you, my lady, my lords, to read that paragraph?
Paragraph 21.
21. And why this is an important paragraph is because of the contrast between what happened in that case and what happened at the trial of our case, where we don't have any evidence from the bank official who attended the meeting with Mr. Moree and Mr. Leonard on the 20th of November 2009. But we do have in the Aroso case what might be described as almost disinterested evidence from the bank official, Mr. Horsley, that he explained precisely the effect of the joinder of the account. And specifically, the understanding that the deceased intended to transfer the beneficial interest, and those words are actually found about 8 lines from the foot of that paragraph. Turning back, my lady, my lords, to the clauses in question, they appear at paragraph 13 at page 622. And this also is a clause that distinguishes itself, and from our case. It makes it absolutely clear that the funds and assets deposited and which may be hereafter deposited shall be in our beneficial ownership and shall not be held by us upon trust for any other person or persons whomsoever. We fully understand that in the event of the death of one or more of us, the survivor or survivors shall remain and be entitled to the entire assets deposited with you for the account. In those circumstances, one would feel that the learned judge would have raced to the conclusion that it was clearly the deceased's intention to transfer the beneficial interest in the monies standing to the relevant account.
Would it not have been equally clear that beneficial ownership was intended, even if the word beneficial had not been there, simply by virtue of the survivorship clause? And what can a survivorship clause like that mean, other than that the survivor can take the money out lawfully?
If you delete beneficial ownership, then obviously you have to construe the remainder, and it probably would have been clear enough to come to the conclusion to which my Lord Sumption suggests.
Is there any material difference between the survivorship sentence in this form and the survivorship sentence in the form that we have?
There is. I better take your lordship to that.
Well,
I mean, on your
I don't want to
case-
take you out of your...
No, I've been taken out a long time ago, my lord, so it's a bit late to be suggesting that I go back.
And on your
You didn't
case,
fight hard enough to stick with your course, did you?
Well, I thought I ought to be amenable just to begin with before my natural absurdity came out.
but I just want to understand this. I mean, your case is you have to look at that clause in the context of the other evidence.
Yes.
And in this case, there was clear evidence of what was intended. Are you saying that even without that evidence, that clause, and without the reference to beneficial ownership, that clause would have been good enough?
Well, Mr. Justice Lawrence Collins may possibly have thought that that was enough. I say that because of paragraph 22 of his judgment, which
Yes,
is at
but I'm
page...
more interested in your submission.
My submission is no.
No.
That just because a clause is clear in a banking document doesn't mean that it is conclusive as to the intention of the party signing the document. We're not here, and this is the important thing, we're not here construing the contract which is contained in the banking application forms. This isn't, as it were, a dispute between the person signing the document and the bank. This is, and the process upon which this board is engaged, is seeking to ascertain the actual intention of the person who signed the banking documents. And as we know, Lord Sumption gave a lecture to Keble College quite recently on interpretation of contracts, and we all know that when one is seeking to ascertain the objective meaning of a document, that is an objective analysis, as it were, when we look from a helicopter down at the document, trying to work out what it means. But there's a difference between that and using words in a document or phrases in a document to ascertain the actual intention of a party to the document, rather than the objective mutual intentions of the parties to the document. That's a slightly different contextual exercise. If one goes to paragraph 22, the learned judge, after reference to Vandervelde, says, if as a matter of construction of the document making or directing the transfer, it is possible to discern the intentions of the transferor, that's an end of the matter, and no extraneous evidence is admissible to correct or qualify his intentions, so ascertained. But that is only a presumption, so ascertained. But if the document is silent, then a resulting trust arises in favour of the transferor, but that's only a presumption and is easily rebutted. I don't really want to construe what the learned judge there did as though it were a contract or a statute itself. But the task upon which Mr. Justice Lawrence Collins was there engaged was trying to discern the actual intention. And whilst I suppose it may be possible in certain circumstances where the construction of a document is very, very clear, a fortiori, when the document is actually explained correctly to the transferor, that is the end of the matter, and no further extraneous evidence is admissible. What is noteworthy in this case is that...
but he does say that, if you like, heads off any resulting trust analysis. You never get to a resulting trust analysis.
Yes, because...
Rather than just saying it's an elephant in the scales.
He does say...
Of a resulting trust analysis.
Well, what I suspect he Yes, he does, because the intention is absolutely clear from the terms of the document. That's what he says.
But it doesn't much matter whether you say there was a resulting trust, but it was clearly rebutted, or there wasn't one at all.
Makes no difference, no.
So you've got to submit either that Mr. Justice Collins was wrong about that, or that the clause 20 is unclear.
Or both.
Or both.
That's right. I don't really know how necessary it is to say that Mr. Justice Collins was wrong right there, because what is interesting about Mr. Justice Lawrence Collins's decision is that, notwithstanding what might be described as the fairly clear terms of paragraph 13, he went on at paragraphs 35 and following not to confine himself to the terms of the clause, but rather to consider what, if the clause had been entirely clear, he would have regarded as wholly inadmissible evidence.
I mean, it's difficult to see how it could have been any clearer than paragraph 13. So
Well, which makes
one
one...
of us is not clear what his proposition would apply to.
Well, exactly so, my lord, and therefore one doubts, if I might respectfully suggest, that when he said that that is an end of the matter, he really meant it was a complete end of the matter. He might have thought it was a very powerful point. But I certainly don't shirk, my lords, from saying that if what he was suggesting, which, of course, on the face of it, it looks as if he was, that if the words were clear as to intention, as a matter of pure construction, that was an end of the matter,
Yeah.
I would suggest that he's wrong. And I would suggest that the correct approach is to take into account that factor. It may be very weighty, but take into account that factor, as well as all the other circumstances which go towards the ascertainment of actual intention. And in my respectful submission, the clarity of the construction of a clause cannot make inadmissible other evidence which goes to actual intention if that other evidence is cogent evidence as to actual intention. There's no common sense in saying that just because the construction of a document is clear, therefore actual evidence of actual intention, which is contrary to that document, when one is not seeking simply to construe the document but to ascertain intention, all that other evidence is inadmissible.
Would it have been conclusive as a matter of construction as between the bank and the account holder?
And the deceased.
Yes.
Yes, probably it would be.
Can it be
But can I just interrupt?
as between those two, but not conclusive as between others?
Yes, that's
bearing in mind that the asset in question is a right against the bank.
Well, I would firstly approach that from, as it were, an academic point of view, rather than from a practical point of view. The academic point of view is that the two exercises, as I've tried to indicate, obviously ineffectually, the two exercises are different. The exercise of trying to ascertain what the mutual intention of the parties is objectively, in accordance with the normal canons of construction under English law, is a different exercise from the exercise which is to ascertain, or the ascertainment of the actual subjective intention of a transferor. It may be that the former is relevant to the ascertainment of the latter, but it doesn't mean that the former answers the latter.
I'm still struggling with the question. If the two participants as account holders in a joint account, at the moment of its opening, and I think in this case at the moment of the transfer into it of the sums which we're now concerned with, both sign a document which clearly records the beneficial interests of each of them in the shows in action constituted by the account, why shouldn't any subsequent dispute about that be determined on the true construction of the document which they've signed?
Because the relationship between the transferor, the account holder, and the bank is a relationship, generally speaking, of creditor and debtor. And what the bank wants to know...
I understand the bank has an interest in wanting to know what the position is. My question to you is why, if a dispute subsequently arises between one of those two account holders and the successor in title, that is the estate of the other one after he's died, why shouldn't what they have both signed up to be the answer to the question raised in the dispute?
I'm so sorry, my lord. I was not answering the question that you were asking.
No.
Because I was just looking at the Aroso situation, where the two account holders are not signatories to the bank documents. You only,
No, I'm sorry, I'm perhaps jumping.
and that's what I was answering.
Yeah.
Now I understand that you are asking where both account holders are signatories to the document. Well,
As here, I think.
as here, and I'll come on to whether these documents are clear or not in a minute. In my respectful submission, if as a matter of contract between them, and it has to be between them as opposed to severally between each of them and the bank, if as a matter of contract between them, I would have to consider that from a different perspective from that which I am considering them. Because what we have here is not an agreement, a tripartite agreement as such. What we have here are agreements between the account holders and the bank, and not between the account holders themselves.
But if two account holders each, let us suppose independently, agree with the bank that the bank is to treat its debt as being owed to the survivor after the death of the first to die, why isn't that just as good?
That may be just
That characterizes the entitlement to the asset. The person entitled to the asset is the person to whom the bank owes the money. So if the two account holders agree that the money is to be owed to the survivor, that must be the end of the matter, however much evidence there is of a different intention, short of non est factum.
Short of non est factum, that would
not being run here.
That would probably be an end of the matter as a matter of each individual's contract with the bank, so that as against each, the bank has or can say, this is what we have agreed as to the disposition of the particular shows in action. And neither contracting party with the bank could complain against the bank in relation to that, my lord.
So this really means that your case depends on establishing that as a matter of construction, the clause 20 is unclear.
Well, I would put it...
It doesn't, does it? I think that's misunderstood with respect. It's not how I understand what you're saying.
No, it's not it's not what I'm saying.
And you're saying that the contractual position vis-à-vis the bank doesn't necessarily settle the question which we're having to deal with.
That's what I am primarily saying, my lord, yes.
I mean, whether you're right or wrong on that, I don't know, but
Sorry.
I'm very anxious you shouldn't be conceding. I'd be pressed to concede points which you're not conceding.
Well, my Lord Sumption, it's very difficult to deal with sometimes.
Oh, I couldn't possibly comment.
I'm still struggling with the notion that when two people go to a bank to set up a joint account and both sign a document which appears to record the beneficial interests in the joint account, it can be described as an agreement between each of them with the bank, but not representing any common ground between them, because it's of the essence of a joint account with a bank relationship that both the joint account holders are ad idem as to what it is the bank is doing when it's operating the account.
But that is a perfectly legitimate approach, my lord. But why it is a legitimate approach is because what it does is evidence the actual intention of the parties, rather than looking at it as a matter of pure construction. That's why it's a legitimate approach. And that's why, if the document is unclear, whether, let's just surmise for a moment, my lady, my lords, that the document is not the clearest document in the world. It is quite unclear. But if you were to go before a court would conclude that the meaning is X, that the beneficial ownership passes, even though it's really very unclear, and it goes all the way up to the Supreme Court, and there are different people taking different views all the way up. Now, in those circumstances, while the document has a certain meaning as a matter of law, my submission would be that that document has only limited weight in relation to the question of what the actual intention, subjective intention, of the transferor was. Even though, as a matter of law, the document may as between each of the joint account holders and the bank have a certain meaning. So you go back to the original question which I was putting, or the original submission that I was putting to you, which is that the question of analysing a contractual document to try and ascertain its objective meaning does not answer what the subjective intentions of the parties to that document were.
The trouble is that the subjective intentions, the question posed by the law relating to resulting trusts, the law relating to resulting trusts was really developed for cases where all you've got is the gift and a certain amount of surrounding evidence in some cases about the relationship between the parties and what the intention must have been. You've got an apparent gift, and the question is whether it's a real gift. It didn't arise in the context of cases where the parties signed a legal instrument which purported conclusively to determine it. I just wonder whether the law of resulting trust has any place if the transaction objectively, as a matter of law, disposes of the equitable interests and the legal ones.
The board recently, in a case to which you, my lord, was a party, indeed my lady, Lady Hale, and my lord, Lord Wilson, were a party. It's a case Mar and Collick, which in fact you decided, I think, earlier this year. And my lady, Lady Hale, as I recall, said that in relation to resulting trusts, what one is seeking to do is ascertain the actual intention of the parties. And the context counts.
A resulting trust is a way of trying to establish the most likely intention.
Yes,
It's a mechanism imposed upon the property which is there to reflect what seems the most likely intention, is it not? The resulting trust is a mechanism to reflect what the best guess one can make about what the intention was.
Well, that's why I began my submissions by saying that what the law does in relation to what appears to be a gift of this nature is to presume that that there was not an intention, when there's no consideration, to presume that there's no intention to gift in this case, monies absolutely. And it's because of that presumption of fact that one has, as my lady has just said, a resulting trust. But in relation to the antecedent question as to the ascertainment of intention, I had understood my lady to say, well, in fact, it was the judgment of, or the advice of Lord Kerr in that case, who was actually quoting from an earlier decision of yours, that the context counts for, if not everything, a lot. And
I think the question is, however, do you ever get to a resulting trust analysis where what Mr. Justice Collins, as he then was, calls the document making or directing the transfer, which in this case incidentally describes itself as an assignment in Clause 20, is declaratory of the beneficial interests?
I mean, the problem we have, I think, is that the case has proceeded as far as this on the basis that there was a resulting trust, and the only question was whether it was rebutted. I mean, what's being put to you is actually that's the wrong premise, and one never gets to it, which is,
take a transfer.
may or may not be right, but it's certainly rather different from the way the case has proceeded hitherto.
it's different. Forgive me,
Take
my
a
lord.
transfer of land by a deed of, in the old days by deed of gift, by a modern transfer by way of gift, to two joint owners. If that declares the joint owners' beneficial interests, you don't get anywhere near a resulting trust. That's the end of the matter.
There's lots of authority for that. Probably.
Yes. And why is this any different? Where A, it is the document, as Mr. Justice Collins says, making or directing the transfer, and in this case, expresses itself to be an assignment.
Well, it's because if you're trying to, by the way, I've now got rather stuck into resulting trusts when, in fact, my submissions were going to be that it doesn't really matter about resulting trusts because the learned Chief Justice found as a fact that Mr. Leonard never intended to transfer or to gift the monies to Mr. Moree when he joined him to the accounts. So it doesn't actually matter whether you take it as a resulting trust and therefore there is a rebuttable presumption, or you don't get to the resulting trust in the first instance because the intention has been made so clear that you don't need to do it that way if you don't want to.
But you have to get to resulting trust if you're going to rely upon the subjective evidence of intention as being relevant, don't you? That's the only vehicle, that's the only means by which it can be relevant.
Well, no, because the resulting trust is based upon a presumption of law, which the law makes if one goes through the authorities, which is that the intention is not to gift.
It's the legal consequence of the imposition of a burden of proof, and what I think is now generally reckoned to be a fairly weak presumption if there is some evidence that the court can get its fingers on.
But you're right, but that's why I'm not, as it were, putting my eggs into that basket. I'm saying, as you know, that as a matter of fact, Mr. Leonard didn't have the requisite intention on the evidence before the Chief Justice. But if one needs to go and have a look at the terms, if you go to the bundle, I'll take you to it. It's in the record. Where is the clause? If you go, please, to page 190, electronic page 190, you will see the account and services application. And because this is difficult to read, I'll take you to where the clause is set out in the judgment at first instance, which might be more helpful. But whilst we're on this document, since it was going to play a part in my submissions, can I ask you to look at the bottom left of page 190, where you see rather faintly state purpose of account to pay utilities. Do you see that just towards the bottom at page 190? And then if you turn...
Sorry, I haven't found that. Oh, I see.
Right
Yeah,
at
I've
the
got that.
bottom
Yeah,
there,
I've got it.
And then if you look at section 5, which is at page 192, this is the
The
section...
account was actually completed by a bank official, was it?
This was completed by a bank official, yes.
Yes. What, the whole of it, or?
Yes, if you go on to, my lord, you'll see the signatures firstly at 193, where we have the applicant's signatures. That's the declaration. And I think above that, we have, I think that's the signature of the bank official, albeit it's under a joint account mandate. And you see the stamp in any event.
Are those the initials of the deceased and Mr. Moree, saying enough for one person to sign?
I think so, my lord.
Yeah, they definitely are, aren't they?
You should ignore the stamp, by the way, at the bottom right, because that's simply the stamp, I think, at the time that this document was produced by the bank for the purposes of these proceedings. If you turn to section 5, personal account agreement, and you turn the page to 193, you'll see clause 20, the joint tenancy clause. And since that is not particularly well printed, you can find it at page 088 at paragraph 6 of the Chief Justice's judgment.
it includes the assignment,
It includes the
each to the
assignment.
other, of any separate ownership of any money going into the account.
Yes, it includes the assignment, but all the assignment does, my lord, is, as it says, to make the prior words effective. It doesn't add anything to the prior words in terms of legal consequence for the purposes of determining whether the beneficial interests in the monies have passed.
That explains why there's an assignment, but there's still an assignment.
There is still an assignment, but you can have just as much an assignment of a legal interest as you can of a beneficial interest. So that's why I say it doesn't actually add anything. So what you have to do in the primarily is to construe the immediately antecedent phraseology, which, as you see, is it talks about the monies, which are now or may later be put into the account, is our joint money with the right of survivorship. And if you track through the authorities, and you go, for example, to page 563 of the electronic bundle, where you see paragraph 86 of our case, and you start at 86.3.2, and it's the footnote, and as set out by, in Australia, property is used in the law in various senses to describe a range of legal and equitable estates and interests, corporeal or incorporeal. And then we have, going to jurisprudence, Hofelt identified the term property as a striking example of the inherent ambiguity and looseness in legal terminology. Then you have, in our own courts, my lord, Barons Martin and Bramwell, saying in Slater and Pinder, in the context of ascertaining with whom beneficial title lies, that the word property is ambiguous. And then you have Madsen, another Supreme Court of Canada case, which is in your bundles.
Well, that was a companion to Pecor.
It was something to which, yes.
No, it was,
Handed down on the same day.
It was
Yes.
about the same disposition.
It was, and one referred to the other. I think Pecor referred to Madsen. But, and the same judge dissented, my lady, as it happens.
I don't think that Justice Abella dissented. She reached the same conclusion in Pecor for different reasons.
Well, I'll check.
I've just been reading her judgment.
I'm grateful, my lady.
So that's Madsen, is it?
That's Madsen, my lord, yes.
It was all about whether the father intended to make a gift of the money in the joint account to one of his daughters. Pecor was a dispute between that daughter and her husband, and Madsen was a dispute between the other siblings and that daughter. She won them both.
Yes. Thank you, my lady.
But sorry, where have we got to on that? As far your point is that it's simply authoritative of the fact that where there's no reference to beneficial entitlement, the word property is not clear.
That's right, my lord.
But that doesn't deal with the question of survivorship. Which
Doesn't deal with the question of survivorship, no. And I'm sorry, my lady, you're absolutely right. She was dissenting from the reasoning. Forgive me.
That's because she was relying on the presumption of advancement, and the majority were relying on evidence of intention.
But in relation to the joint tenancy clause that we have here, the repetition of the word property in the second sentence, which identifies what the meaning is of the preceding sentence according to this clause. This means that if one of us dies, all money in the account automatically becomes the property of the other account holders. That, in our submission, doesn't add anything to the ascertainment of what property means in the preceding sentence. Nor does the assignment. The assignment is no more and no less than that which is required to make effective what is provided in the preceding sentence. What I can safely say, my lords, well, I hope I can safely say, is that this particular clause is not clear. In fact, it is positively unclear. As to whether there was, whether objectively or subjectively, an intention to transfer the beneficial entitlement or interest in the monies standing to the credit of the account. What you don't have is a model of clarity such as existed in Aroso and Coutts, which obviously influenced Mr. Justice Lawrence Collins in that case. Didn't influence him, as I've indicated already, so far as to exclude all the other evidence which he then considered in trying to work out what the actual intention of the deceased in that case was.
Why do you say that survivorship adds nothing? I thought that was quite striking because it shows who's going to get the money if one of them dies.
What, in my submission, it means is that the survivor, obviously, by surviving, takes all the interest in the property to the exclusion, obviously, of the deceased, but no more, my lord, than that which he already had.
So he holds the rest on trust for the estate of the other.
Yes.
Slightly odd way of expressing that, isn't it?
Well,
It would also be a rather odd thing to do.
Yeah.
Wouldn't it?
Particularly if the purpose is to pay his utilities, because he's not going to need them very much.
well, the purpose to pay utilities, which
No,
is...
but I mean, sorry, that's a distraction. But I mean,
No.
the survivorship words, I mean, why would that suggest simply an intention to create a trust in favour of the estate, of the other party's estate?
In my submission, the survivorship right doesn't add anything other than...
I know you say that,
Yes.
but I wonder why it doesn't.
Well, because if you didn't have at the time when the account was opened an intention to gift the monies to the other account holder, then the right of survivorship, which exists in relation to all joint tenants, itself doesn't add that intention.
Well, you're putting the cart before the horse, because whether the premise is correct depends partly on what we make of the survivorship provision.
Well, you can't address the survivorship provision unless you actually look and see what the explanation is in the subsequent sentence. The survivorship provision is specifically explained, and it says if one of us dies, all money in the account automatically becomes the property of the other account holder. In other words, the property is the same legal estate in the money which was previously enjoyed. So you have to go back to the original question, which is what was the estate which was originally enjoyed? And the right of survivorship doesn't give any more of that estate to the survivor.
Mr. Keeley, we have asked you lots of questions. You have 2 minutes. What would you most like to say? Oh, you've got a long way. What would you most like to say in those 2 minutes?
Right. Well, what I'd most like to say, my lady, is this. I'm going to ask you to read the judgment of the Chief Justice with care. What you will find is that he took into account, and explicitly took into account, all the circumstances of the case, including the clause with which we're concerned. The Court of Appeal explicitly acknowledged that he took into account all the circumstances and all the relevant evidence in the case. That's the first thing. Secondly, the reasons given by the Court of Appeal for disturbing the judgment of the Chief Justice were themselves, we say, what the Court of Appeal did is it found other factors, or factors which had already been taken into account by the Chief Justice, and came essentially to a different conclusion on the same factors. But the trouble is I haven't developed anything, but you can take one thing which obviously the Court of Appeal was particularly taken by, which was an argument actually not put before the Chief Justice. As you know, there was a codicil following the visit to the bank. There was a codicil. And the Court of Appeal explicitly said, well, the reason why the particular legacies to those particular organizations, the Humane Society and the Salvation Army, were taken out was because it was apprehended, or possibly apprehended, by Mr. Leonard, that having given the money to Mr. Moree, there was insufficient in the estate to satisfy the preceding legacies. And all you have to do is look at the will yourselves to identify that that was a wholly incorrect analysis. Because
the original will had already provided for that.
The original will had already
By
provided.
saying insufficiency must come out of that.
Exactly. So you have additional reasons, as it were, put on by the Court of Appeal in circumstances where those did not sustain the conclusion, which at least nominally the Court of Appeal came to, which was that the learned Chief Justice came to a decision to which no reasonable tribunal, properly guided, etc., could have reached or could legitimately have reached. All that the Court of Appeal actually did, and I'll finish, my lady, all that the Court of Appeal actually did was to come to a different view on the evidence, and at the most that one can say in their favour is that it was a different view in relation to evidence upon which reasonable minds could reasonably differ. They both took into account the same factors, bar the one I've just mentioned, which was an additional factor and shouldn't have been taken into account. They both weighed and evaluated those factors, and one tribunal came to a different view from the other tribunal. And that is not a proper basis for the exercise of an appellate jurisdiction reversing a trial court judge. So I hope that that is not necessarily satisfied you, my lady, but it's the best I can do in the minutes available to me.
Yes, I mean, just to take up an extra minute. I mean, well, the problem in a way is what's being put to you is a way of looking at the thing which really hasn't been the basis on which the case has been argued. The basis on which the case has been argued, which is the question of fact. Your case is actually very simple. The judge reached a conclusion which was open to him and there was no basis for interfering. That's all set out. But I am, for my part, concerned that you have said everything you need to say on the alternative basis, the rather more radical basis that really resulting trust doesn't arise at all. But are there any other authorities we ought to be looking at on that?
No, not that I can think of. Not that I can
there's
think
no authority which actually deals with the meaning of survivorship. You've showed us authorities on the ambiguity of property, which I understand, but not on survivorship.
I'll have to look at that, my lord, because there is something in the back of my mind which may educate me better if I have a look at it. But my case on the survivorship clause and the questions being asked by my lords, Lord Sumption and Lord Briggs, where it's no good taking me to task about the survivorship clause if it's not a clear document. Yeah. If it's not a clear document, it's actually not a terribly useful document.
Yeah, well, you have said that a few times, so...
Yeah. Sorry?
No, don't apologise. You've been asked again another question, the same question.
No, well, I shouldn't have repeated my original answer to a different question.
But we had better move on. Thank you very much, Mr. Keeley. Mr. Goodcamp, do you follow? Yes. Mr. Parker.
Yes, much obliged, my lords. I will begin where my learned friend left off for ease of reference and for continuity's sake. But before I do that, it is important for me to emphasize, as counsel throughout this matter, that one of the things that has to be central to the court's deliberation is the intent of the deceased. That is what we are concerned with here. On the evidence, you will see the deceased made his last will and testament in October of 2009. In November 2009, he converted his account into a joint account with the respondent, thereby granting him the interest that he had in the $190,000 that stood on that account at the date of the deceased's death. The deceased then passed in February of 2000. Actually, in January of 2010, he went on to make a codicil. And then he passed away in February. One of the things when we read this narrative, this factual narrative that is very important we submit, and we recommended this to the Chief Justice, we recommended it to the Court of Appeal, is that the deceased was clearly contemplating his mortality. He made his will, he gifted the account to the respondent, he made a codicil. I want to spend some time on the matter of what the codicil achieved and the inference drawn from that, and we would say the reasonable and proper inference drawn from that by the Court of Appeal. When we look at the deceased's will, it is explicit in his will that he was concerned about the ability of his assets to meet the bequests. Hence, he made the provision that should his assets be insufficient, you go first at the charitable donations to the Humane Society and the Salvation Army. This is what he did in October. In November, we submit, as the record reflects, he gifted the account, the $190,000, with the right of survivorship to the respondent. And we submit that he was cognizant of what the joint tenancy clause meant, what the survivorship clause meant. And I humbly disagree with my learned friend that the survivorship clause was not speaking to the continuity of whatever interest may have been created as when the joint account was open. It was to specifically make clear between the parties that the survivor between us shall take the property to the exclusion, we say, of the estate or any other extraneous claim. We also submit, my lords, that the assignment, which is specifically identified in the clause to make this legally effective, that language we submit is intended to avoid situations like the very litigation we are engaged in, so that it is beyond clear as to what our understanding of the contractual arrangement between the parties is. So when we turn to the codicil deleted bequests or revoked bequests in the total amount of $150,000 to the Salvation Army and the Humane Society. Had that not been done, the balance of the estate at present stands, according to the evidence, at about $180,000 at present, subject still to estate fees and other expenses, which may then take up the notional balance of $30,000 potentially, which would mean and which would make a nonsense, in my humble submission, from Mr. Leonard's perspective, of the residuary bequest. The evidence before the court demonstrates that Mr. Leonard, not only from the evidence of the respondent, but the evidence of the appellant, was a very precise man. When we examine the contents of his will, he was a businessman who had accumulated a certain amount of wealth. And we submit that as we explore or we consider these documents, as we consider the bank account documents, we submit it would be a reasonable inference that he understood what he was doing, that he intended what he was doing. And furthermore, it is not for the parties to seek to disturb evidence of the deceased's actual intention. His will demonstrated his intention as at the date of the will. His actions in the banking documents demonstrated his intention as at that date. And the codicil demonstrated his intention as at that point. All of those things we submit were reasonably
If you're
read
talking about
together.
if you're talking about his subjective intention, the problem about that is that it depends on whether his attention was drawn to clause 20.
Yes, yes, my lords.
And the evidence was given that his attention was drawn to clause 20, but as I read the judge's judgment, he didn't believe it. That's a difficulty for you, isn't it?
Well, my lord, what is difficult in those circumstances is not necessarily the Chief Justice's disposition. One of the things that I would like to emphasize to the panel is that when we're considering what the rebuttable presumption is, it is a question of the burden of proof. And it is a matter that is discharged on what we say is the balance of probabilities. That is an exercise. And one of the things that when you examine the record, we submit would jump out, as it jumped out to the Court of Appeal, is that on one side, you have the unchallenged, frank evidence of the respondent. You have the evidence from the deceased's will, deceased's bank documents, and his codicil, giving the general, giving the narrative of his estate planning. But what is absent and what distinguishes this case from the majority, if not all of the other cases, is that the appellants led no evidence as to the deceased's intention. This was not a case where there was a hotly contested argument that Mr. Leonard would never have wanted to disinherit or to have preferred Mr. Moree as opposed to the appellants. The appellants gave no evidence as to the deceased's intention. And we submit, my lord, that that is very telling, and it is a very significant distinguishing factor. The two pieces of evidence relied upon as a premise upon which to challenge this gift is the notation that my learned friend pointed you to with respect to pay utilities on the banking forms, which notation we submitted, which the Court of Appeal accepted, spoke to, as it says, the purpose of the account. The historical purpose of the account had been to meet Mr. Leonard's utility expenses, etc. However, it did not purport to, and we submit that it could not purport to trump or to speak to the reason Mr. Leonard made the gift to the respondent. That is a separate issue. And we would submit, my lord, that the learned Chief Justice appeared to prefer an implication drawn from an unattributed notation that was neither made by the deceased nor the respondent, nor anybody could anybody speak to it, did anybody speak to how that came about, as opposed to the
inference one would draw from the document itself. It's an integral part of the form. It looks as if the bank official completed the form sitting in front of,
yes, my lord.
The deceased and Mr. Moree. The inference one would draw is that he must have been told that.
Indeed, my lord, but when we look at the authorities, the mere fact that the funds gifted remained in the use and in the control of the donor is not in and of itself, as the authorities we've placed before you demonstrate, conclusive as to intention. So we would say, my lord, that notwithstanding any suggestion that Mr. Leonard intended to continue to meet his expenses from this account, did not detract from his intention to benefit the respondent.
No, I mean, its relevance is that it's an explanation of why he might have made him a joint signatory, other than an intention to give him the money.
Well, my lord, we also submit that the evidence before the court, the uncontested evidence of the respondent, was that he was attending to Mr. Leonard's needs at this time in any event.
Well, except that one thing he couldn't do is sign checks on his account.
And furthermore, there were more options open to Mr. Leonard than to creating this joint account to facilitate that further. But the point remains, my lord, that as the evidence of the respondent demonstrated, that from the date of the deceased wife's passing in 2007, he had taken up a more involved role in assisting Mr. Leonard in his activities. But turning to why we are here, my lords, we are here because my learned friend seeks to suggest, or suggests rather, that the Court of Appeal inappropriately interfered with the judgment of the Chief Justice. We submit, my lords, that the well-reasoned and clearly articulated judgment of the Court of Appeal demonstrates that the Court of Appeal was within the four corners of its jurisdiction and a legitimate exercise of that jurisdiction to set aside the Chief Justice's judgment. Not only was his judgment found to be unreasonable in a Wednesbury sense, but the Court of Appeal also determined, as it was open to them, that his decision was not supported by the evidence, which we submit goes back to the point that, as is evident on the transcript before the Court of Appeal, the appellants led no evidence, and as to the deceased's intention. And we submit, my lords, that when you weigh in the balance the question of what Mr. Leonard intended, you have the unchallenged, uncontroverted evidence of the respondent. We submit that you have the, as the Court of Appeal determined, pellucidly clear bank account documents. We submit, my lords, that you have the evidence of his subsequent actions, which we submit demonstrate that the deceased was cognizant of the fact that he had himself diminished his estate and therefore deleted the vulnerable bequests to the Salvation Army and the Humane Society. All of this evidence from the respondent's perspective as to the deceased's intention to benefit him. And when we look at the context of the will, the Chief Justice sought by his judgment, let me take the court to it, page 100 of the electronic records, starting at page 99, paragraph 31. The Chief Justice stated in his judgment, more significantly, it must be recalled that in clause 6 of his will, Mr. Leonard specifically referred to cash in banks, at the banks. And out of that cash, inter alia, he made a bequest to Mr. Moree and his wife of $55,000. If I were to find that Mr. Leonard intended to benefit Mr. Moree when he made him a joint account owner, it would mean that in October 2009, Mr. Leonard gave Mr. Moree $55,000, and out of that cash in the banks, but a month later decided to give him all of the cash at First Caribbean, more than 3 times the amount gifted in the will. This is highly doubtful. Now, my lords, we again recommend the provisions of the deceased's will. The deceased gave Mr. Moree his home, which home the deceased's evidence, the respondent's evidence demonstrated was valued at approximately $450,000, in addition to this cash bequest. So if we were looking at the totality of the benefit to the respondent under the will, the $190,000 doesn't even meet the halfway mark. But yet, the Chief Justice sought to suggest that somehow this was a disproportionate action, without really, we submit, considering what the intention of Mr. Leonard was. Now, we also taking to the final, the penultimate sentence, the Chief Justice of that paragraph, the Chief Justice said, in my judgment, the bequest in his will expressed Mr. Leonard's intentions as to how he would benefit his friends, including Mr. Moree, as well as Mr. Whitlock and Ms. Jack. When he changed his mind, he made a codicil. Now, we submit that the Chief Justice did not explore that proposition. Although he acknowledged that the deceased clearly changed his mind, we are left to assume that we mean that he changed his mind simply about giving anything at all to the Salvation Army and the Humane Society. But what we submit, my lord, is that the deceased did change his mind, and in November, he gifted the funds on this account to Mr. Moree, and cognizant of that fact, in January, he deleted those bequests.
I think the codicil carries the signature of Mr. Pinder.
Yes, sir.
Did you cross-examine Mr. Pinder about the circumstances in which that codicil was made?
No, my lord, we did not cross-examine Mr. Pinder on that issue. One of the criticisms of the judgment of the Chief Justice's handling of the trial, as reflected in my case, is, as the transcript reflects, it was a very combative exercise seeking to explore your issues. You know, there's an instance of attempting to put my case to Mr. Whitlock with respect to the deceased's intention to benefit the respondent, and the Chief Justice summarily declared, how would he know that? Which deprived Mr. Whitlock in this instance of an opportunity to speak into whatever he may have known about the deceased's intention. Because the reality is, in the majority, if not all of these cases, when people challenge gifts, they approach the court, regardless of where the balance lies, to speak to some knowledge as to what the deceased would have intended to the contrary. That is not what the appellants are relying on in this case. They are relying, my lords, on conjecture from the notation on the form, and they are relying on the contents of the schedule of the deceased's estate, which I will take the court to now. What is the schedule? It is at page 176 of the record. These are the principal elements upon which the respondents base the entirety of their case. The premise is, my lords, that
Sorry, what page number was that? I was looking.
176.
I was looking for the schedule.
We there? The premise, my lords, is that the respondent, having executed the oath for the executors, by which they swear to produce a true and correct account of the estate of the deceased, which was on the record prepared exclusively by Mr. Pinder, it is said to have included the $190,000 in First Caribbean in that schedule.
Well, it goes rather further than that, doesn't it, Mr. Parker? Because the actual oath affidavit talks about schedules annexed to this affidavit.
Indeed, my lord.
And you've shown us the first of the two schedules annexed to the affidavit.
Yes, my lord, that's where we are. And it is the respondent's case, and it has been throughout, that this schedule is inaccurate and unreliable and was not put to him for presentation. What I did cross-examine Mr. Pinder about was the basis upon which he prepared the schedule. As Mr. Pinder's evidence before the court demonstrated, he, at the meeting between the parties, took a handwritten note, scrolled some things down, and based upon that, he produced this document. He, as counsel, undertook no due diligence, did no investigation to verify the veracity of these things, but I want to, sticking with the actual schedule, you would see on the schedule it states, under amounts deposited in bank, not at interest, it says First Caribbean, $100,000. Correct?
Yes, everybody seems to have agreed below that it actually says 190.
Yes.
It looks a bit like 100, but it's a poor copy.
Yeah.
And I came to the conclusion in my pre-reading that actually it says 190.
But Lord,
It
that is
doesn't.
not our reading of it. But there is, when you read the total figures do suggest that there is $90,000 unaccounted for. And one could presume that that is what is intended. But the schedule speaks for itself. What we are trying to highlight, my lord, is that when Mr. Pinder presented these documents, and as was demonstrated in his cross-examination, he himself formed no view as to the extent of the deceased estate. His evidence is, I met with Mr. Moree, I took down some notes, and I proceeded on that basis. Mr. Moree's evidence was, I provided him with the information, which by that point would have included the fact that I had already converted that account into a joint account with myself and my wife about 20 days prior to that meeting.
But how, and was Mr. Moree asked about how he came to sign this document then, or swear this document?
Yes.
I mean,
It's a 266, isn't it, Mr. Parker?
You mean that exchange?
In answer to my Lord
Yes,
Carnwath,
Dave.
you see line 13 on page 266? The question really is, asked the Chief Justice, why did you sign the oath saying that the $190,000 was property belonging to Mr. Leonard, when that was not in fact so? And your client says, as I said, I was advised by Mr. Pinder. I questioned the $350,000.
Yes, my lord. However,
Is that your case, that Mr. Pinder made Mr. Moree sign a document which Mr. Moree knew to be false?
no. The evidence shows that later on, when the court is questioning him further, the court at line 1 on page 271 of the transcript. Are we there? Referring to the same schedule, he says, it specifically refers to the bank at First Caribbean. You see that?
Yeah.
The witness, Mr. Moree, I did not see those papers, sir. I signed this form, but there was nothing attached to it, speaking of the oath. The Chief Justice, so you are saying that when you signed this form, yes, sir, you did not see the account, the household goods, linen, apparel, books, jewels, etc., $150,000. You did not see First Caribbean account with $190,000. No, sir. And did you see this? No, sir. But I thought you said earlier, taking the court back to where Lord Justice Wilson took me earlier, but you said earlier that you saw there were mistakes and you drew those to his attention. And he says, well, I did. That's when we were talking. I didn't see this form. So what he's saying to the court, as he said in his evidence, is that when going through the estate originally, Mr. Pinder articulated a certain valuation. And Mr. Moree's focus was that the numbers that came up, that Mr. Pinder came up with, did not reflect the value of the house, which itself, as his evidence indicated, was worth some $450,000. But what he said was that I hadn't seen these documents. You come in, you sign the documents, and you move on. So he's saying that he signed the oath on the direction of Mr. Pinder, but he did not see the schedule. He did not prepare the schedule. That is not in dispute, that he didn't prepare that document. Mr. Pinder said, I prepared it based on my handwritten note of the meeting, which means, and he denied that he saw any documentation, which goes to the heart of the efficacy of that whole process. Because as counsel, he ought to have known that you do your due diligence with respect to the things that you represent to the court. But he admitted under oath in cross-examination that he had done no such due diligence. So, my lords, one of the things that I wanted to deal with is this question of the intention of Mr. Leonard, which is central, and the room for the application, if any, of a presumption in the circumstances. Because it is when the transfer is challenged that the question of a rebuttable presumption arises, and it shifts the burden. And what we submit is that it cannot be ignored that the respondents led no evidence as to that. I can't emphasize that enough. The entirety, as is articulated in the argument before the Court of Appeal, the entirety of their case is premised on whatever inferences they may have been able to convince the court to draw from the notation on the bank form as to the purpose of the account, which we say is determinative of nothing, as the Court of Appeal found, and the contents of the schedule, which we demonstrated before the Court of First Instance was an unreliable document. It was not a document with respect to which any due diligence was done, and had Mr. Pindit examined the bank documentation or consulted the bank, as we submit counsel ought to have done when preparing probate documents, he would have discovered the true state of affairs, which the respondent submitted that he did. Now, we also have to deal with the question of the respondent's evidence. It is a fact that his evidence was not contradicted or challenged in cross-examination as to the deceased's intention. The Chief Justice made an observation that, notwithstanding the honest belief that may be held by the respondent, his evidence could be accorded little weight because it is self-serving. I submit that when we examine the legal basis for the presumption, which is the argument that it is the donee who is best placed to give evidence as to the donor's intention, particularly when they're deceased, to trivialize uncontested evidence as self-serving is potentially setting people up to fail, or parties up to fail, when the court has made no reasoned findings as to credibility or reliability.
Well, it's fairly, I see the force of your point about self-serving. All parties giving evidence on their own behalf are presumably self-serving, but the general tenor of the judge's remarks shows that he did not attach much weight to the evidence of your client. He thought that he was an unreliable witness.
And he explicitly said that.
Yeah.
He explicitly said that. He made no findings to justify it, we submit, but nevertheless, let's say that he attached little weight.
But that's what he says.
Yes, indeed. You have the little weight of the respondent's evidence. You have the weight, which we don't know which side the court fell on with respect to the banking documents, but it is conceded by both sides that they must have some weight. So you have that weight hanging in the balance of probabilities. You have the evidence with respect to the codicil, which we submit and the Court of Appeal accepted, recognized the deceased's acknowledgement that he had diminished his estate to some degree. You have all of this weight hanging in the balance on one side with respect to what the deceased intended on a balance of probabilities. On the other side, you have nothing. The respondents led no evidence as to the deceased's intent, such suggesting that he did not intend a gift. The premise of the Chief Justice's judgment is as though Mr. Leonard died in October 2009 when he made a will. He did not. He continued his estate planning, as the record clearly shows. The creation of a will does not constrain the testator from dealing with his assets thereafter. That is axiomatic. And at every turn, you have the Chief Justice seeking to juxtapose the contents of the will, which do not speak to this account specifically at all, with what the deceased did subsequently. And we say, my lords, that as the Court of Appeal found, when pressing counsel for the appellants at length, where is your evidence? Did you adduce any evidence? Why do you say he did not intend to benefit Mr. Moree? They brought no evidence. They could not answer the question. So when we look at the case law, we submit that it would be a curious result that parties could approach the court with no information, with no evidence as to the deceased's intention, and thereby overturn clear, unchallenged, uncontroverted evidence on the record as to the deceased's intention. So we submit that regardless of the matter of little weight, the Chief Justice had nothing, in our humble submission, reasonably before him to countermand the actual weight of the evidence demonstrating the deceased's intention. And the Court of Appeal's judgment reflects that, because the Court of Appeal itemizes the evidence before the court that tended to demonstrate that the deceased intended to benefit Mr. Moree.
But can I just ask you
Yes.
this? I mean, the point we were going over before, that Mr. Moree signs a document which appears to say quite clearly that this is is part of the estate, this
Yes.
190,000, and you share us his explanations of that. But I have the impression, I mean, this was something the judge made quite a lot of at paragraph 32, but in the Court of Appeal it seems to be rather sort of brushed aside. The Court of Appeal at page R115, paragraph 11, refer to it, and they say, not surprisingly, questions were raised. But it's then sort of rather forgotten about it. I mean, is there any reference to it in the reasoning?
My Lord, there's reference to it in the transcript of
Yes.
the hearing before the Court of Appeal, which made their decision on the day and submitted their reasonings.
Yes, but if one's asking whether the judge had material on which he could reasonably reach the conclusion he did, surely that assigned document by your client is quite, as to what he understood this money to be, it was rather persuasive, wasn't it?
My Lord, on some level, yes, indeed, the Chief Justice had some materials, but there also was the evidence from the author of those
Yes, I
documents.
understand that, and the judge obviously had to assess that, and we have what he did about it. What I find odd is the Court of Appeal seemed to have ignored it.
Well, we submit, my Lords, that it was traversed in the Court of Appeal, and what Justice Isaacs, who handled that particular point in the hearing before the Court of Appeal, specifically found or noted that, in addition, he didn't mention this, but his point was that the deceased had, by the time the oath for the executor had been executed, had already dealt definitively with those funds, had from the 11th of March taken them and converted
Well, you're
them.
saying there's something in the transcript which shows that's...
Yes, my Lord.
Can you give me the reference?
Yes.
Sorry, thank you.
Okay. 1 second.
There's something very weird about this affidavit anyway, which I'll come back to you on in a
Whose
minute.
affidavit?
The one-
There's something very weird about this affidavit, because on any view it's inaccurate,
Yes, indeed.
as you've already pointed out. So I was going to ask you, is there some significance in the Bahamas to the estate being being under the value of $350,000? I imagine that might just possibly have an inheritance tax significance or some other significance, because that's clearly inaccurate because it leaves out the value of the house. And it also leaves out the value of all the other assets which are listed in the note, which is quoted in the Chief Justice's judgment at paragraph 11. Now, they are foreign assets, but it looks as if this document is designed for not necessarily to be an accurate account of the deceased estate, but for some other purpose.
It makes it even odder that it put in the one thing which Mr. Moree didn't think
Yes,
about the estate. But anyway, have you got... I just...
Mr. Parker, picking up my lady's
Yes, that's my Lord.
questions, of course, the schedule of the real property is the second schedule.
That's right.
That we find at 177.
Yeah.
And Mr. Pinder was asked about the London or the UK assets, and his understanding was that there was no need. He said his understanding was there was no need for them to be included. All he had to include was the local assets. That's what he said.
Yeah, that was the exchange.
Yes.
Still,
Well, maybe.
I thought I had a
I'll come back to it if it's easier to do so.
Okay, well, I'll let her find it and I will take the court to it. But rest assured, my lord, that that was something that was traversed, that particular issue with respect to,
Yes, I'd also like to see what was said about it.
So, turning back, my lords, to the question of the jurisdiction of the Court of Appeal, the pitch that has been made, or the presentation that has been made by the appellants, is that this is a case that turns significantly on conflicting evidence and disputed facts, and the reality of it is quite the opposite. Much of the decision in this case was turned on the interpretation of undisputed documentation. The evidence of the respondents and the respondent and the appellants do not principally conflict. The appellants only say, we believe we have an interest in the funds on the respondent's account. And they say that because of the contents of the schedule of the deceased estate. They do not purport to speak to the deceased's intention, which is, we say, paramount in the circumstances. Now, my lords, it is also important when we look at the facts of this case. One of the things that I noted when I read the synopsis of the facts again is that there is a misconception, unfortunately, I would have participated in that, as to what the appellants were seeking at first instance by their originating summonses. The appellants did not approach the court seeking an innocuous declaration as to whether the funds on the account represented assets of the estate or not. By their originating summonses, they sought principally declarations that they had an interest in the funds, and B, that they were entitled to orders for payment from the defendant to themselves. And we submit, my lords, that as has been our position from our submissions before the court of first instance, they are not entitled to that relief.
So the way they initially presented their case was tidied up later.
Yes, it wasn't tidied up, it was tidied up before the board. Because when we look at the Court of Appeal, okay, good. When we look at what happened before the court below, they filed a respondent's notice. And as Justice Conte noted, no parties seemed to be satisfied with what the Chief Justice found. He seemed to have done what sometimes called a Solomonic judgment, where nobody is satisfied. And hence, he ordered that the funds form part of the deceased estate. No loss of costs, go ye therefore. But we submit, my lords, as was articulated in our submissions, he was not entitled to do that. You're bound by your pleadings. They sought a declaration that they had a personal interest in the accounts. They have no such interest. They sought an order that the deceased pay them a third of the balance as it would have been at the date of the deceased's death. They're not entitled to that relief. If the respondent was indebted to anybody, hypothetically speaking, it would have been the deceased's estate, which estate is not a party to this action. Their claims, therefore, we submit, were stillborn. And when we talk about restoring the judgment of the Chief Justice, we submit, my lord, in light of what was before him for determination, it would be wholly unreasonable to restore a judgment that the appellants were not entitled to on the pleadings. So we can't forget how this began. It seems to have meandered along as though this was a straightforward estate action seeking to recoup assets that ought to have been part of the estate, but that's not what this is. This is a personal action by the appellants against the defendant in his personal capacity. And we submit they are entitled to no relief as against him. And their submissions, my lord, would also demonstrate that fact, that they were cognizant of that reality. I'll take the court to it in a second. Sorry, I apologize. It's a little bit warm for me. The original submissions, Chief Justice. I'll take the court to the yes, page 372 of the record. At line 9, Mrs. Farkas. At page 22, the question is, you swore an oath saying that this was correct, this was a correct schedule of the personal estate of Mr. Leonard. Yes, based on the advice of Mr. Pinder. Well, this is the one I want. Well, the appellant is basically saying that he swore an oath, which he now denies. The president says, I don't know that he said that. He said that he swore it based on the information from Mr. Pinder. This is not what I wanted. I wanted Justice Isaacs to say. Because that is taking us back to the first point where my lord took me, where the court thought he was speaking about that, but I wasn't speaking to. You have the submissions? I apologize. I don't want to waste too much of my time. Okay. Yes, it's page 397. I would begin actually rather page 396, line 23. It's a protracted exchange where Mrs. Farkas says, no, my lords, that is not the inference I'm saying. I'm saying that the inference to be drawn from the circumstances is equally that Mr. Leonard may have anticipated that he could be bedridden, that he could be hospitalized, that he would need round-the-clock care, and that Mr. Moree was put in possession of these funds to deal with all of these. The President, there is no evidence of that. There is no evidence of that, though, Mrs. Farkas. But there is also no evidence, I beg your pardon, my lady, if I could refer to the will. What is the evidence that that was his intention? This is the President speaking, what is the evidence that the respondents have put forward to show that that was his intention to use that money in that way? The evidence at trial, my lady, was that the will, that he intended to benefit all the parties equally, the codicil, which does not change the residuary clause to benefit the parties equally, and the oath for the executor. The President, the intention of the will was not to benefit them all equally. Did not Mr. Moree get the house on his own? Yes, he did. Yes, Mrs. Farkas. President, it seems to me that he got more than the others. Mrs. Farkas, then Mr. Moree then signed the oath for the executor, which acknowledged that these accounts are part of the estate. The President, I do not think that, and the Justice Isaacs, but had he not already treated the account as his own? The President, he had already, Mrs. Farkas, he may have treated the account as his own, but he could really not give any interest in the account greater than he had, than the interest which he had. I'm not talking about whether he effectively gave it to himself and his wife. I'm speaking to the fact that he closed out the account, opened a new account with his wife, the joint account holder. He did. So he was effectively treating the account as his. But his behavior is not necessarily indicative of the intention of the owner of the account. it certainly contradicts the information which you are relying on. And we submit, my lords, that that was where the Court of Appeal dealt with the comprehensive list, because this is the part of the exchange where I say that the Court of Appeal was at pains to have the appellants demonstrate what their evidence of the deceased's intention to the contrary, i.e. not to benefit the respondent, came from. And she, Mrs. Farkas, listed what she thought that evidence was. And in turn, they addressed that. So we submit, my lords, that that particular point was dealt with. All right?
Yes, and that page 401, he comes back to that point, and the President says it doesn't help you.
Yeah. So we submit, my lords, that it did not escape the Court of Appeal that was an issue that needed to be traversed. But I would take the court to the submissions of the appellants at page 434 of in the volume 2 of the record. The final paragraph of those submissions. Okay. In the event that the court, this is when the co-executive, Mr. Pinder, approached the court for directions, which application was then aborted, and the appellants began their actions by originating summons. But they did intervene and put submissions before the court in that instance. And I'm using this, or I'm referring to this to demonstrate that the appellants knew what ought to have happened. And it says that in the event, the court should advise Hardis Pinder that David Moree holds the said sum on a resulting trust for the estate and must account to the estate for the said sum. Alternatively, the court should give directions to Hardis Pinder to bring proceedings against David Moree for a declaration as to the beneficial ownership of the funds, and in the event, an order requiring David Moree to account to the estate for the said sum. So when I take the court back to the originating summonses, it is with a view to demonstrating that the appellants were not satisfied with the Chief Justice's decision. They themselves filed a respondent's notice because they brought a claim, as the originating summonses demonstrate, for a declaration of their personal interest in the funds on this account and an order for payment to them. And therefore, we submit, my lords, that the Court of Appeal was not only right for the reasons set out in their judgment to set aside the judgment of the Chief Justice, but we submit that it would be equally unreasonable in the circumstances to restore that judgment, because it doesn't flow from the pleadings and it is unfair to the respondent. The plaintiffs brought a claim which is at law obviously unsustainable. They have not rehearsed those same arguments before you today. They have sought to couch the application as though they had brought a claim for a declaration as to whether the funds on the account belong to the estate or belong to Mr. Moree. But that is not the claim that was before the Chief Justice. That is not the claim that is before you. So that is an essential...
Sorry, can you just remind me where you deal with this in your respondent's case?
Oh, my respondent's case? Yes. The opening.
Yes, it's where you begin.
Yes.
Oh, I see.
Oops.
Yeah. All right, thank you.
The respondent's case is, don't get shot. Where's the...
That's all right, I mean, I've got it now, yeah.
You've got it?
Yep.
And we can look at the originating, or one of the originating summonses on page 27, can't we?
Yes, sir, my lord.
Show the relief that was being sought then.
Yes, my lords. We open with that point because we believe that, aside from the fact that we believe that we are correct on the submissions as to the law on resulting trust, we don't resile from our arguments on that basis. But when we talk about conducting a review of the decision of the Court of Appeal, it is incumbent upon us as counsel to remind the court, or to highlight to the court, the fact that the appellants have brought a wholly different claim, and they are not entitled to the relief sought upon that claim, which is a case that the respondent was not called upon to meet. And they ought to bear the consequences of that failure. Now, I don't want to leave this without getting to the Oroso debate that my learned friend got to spend some time with. But now this may be my jurisprudential view, but as the case law demonstrates, it is not the intention of the court, or the role of the resulting trust is not to defeat the party's intentions, it's to discover the party's intentions. And it is submitted that when the party's intentions are clear, the room for application of the rebuttable presumption is minimal, if any. And when you juxtapose the clear document citation and the clear demonstration of intent with the fact that the appellants led no evidence as to intent, the question becomes, why are we even conducting an investigation as to intent at all? Because when you look at Oroso and Picor, you're dealing with competing relatives, people who believe that they have equal esteem in the eyes of the deceased, and who have accounts of what mother said to me and what mother did. In this case, you have none of that. You have the position of the respondent, who, by the evidence of all parties, had a very close and personal relationship with the deceased. The evidence of the respondent that he and the deceased had been going through the exercise of preparing for the deceased passing well before he executed his will. And you have the evidence of the will itself, where the deceased not only gives him over and above that which he gave the respondents, but he also bequeaths him the house wherein his mortal remains and those of his wife reside presently. It is clear who the deceased was, who the respondent was to the deceased. And the authorities demonstrate, it's Picor, that the relationship between the parties is relevant, is a relevant bit of evidence. And it is submitted that, as is stated in Picor at paragraph 44, the presumption only determines the result when there is insufficient evidence to rebut it on a balance of probabilities. We submit that the Chief Justice did not consider the evidence of the closeness of the relationship, and it ought not to be trivialized, because that closeness speaks to the fact that when you have the respondent giving evidence as to what the deceased told him, I'm giving you this house, the house needs repairs, I know that you can't afford to, as is reflected in his affidavit, so you need this money to meet those expenses that I'm now putting on you. And then you have the reference in the bank documents that speak to utilities. And as the Court of Appeal noted, the person who would inherit the burden of those utilities would be the respondent in this case. So when you have what we submit is overwhelming evidence that not only was the deceased making end-of-life preparations, and in fact died within months, a few short months of this, you have the evidence of his close and personal relationship with the respondent. And you have the fundamental lack of any evidence as to intention from the other side. So, unlike the authorities relied upon by the Chief Justice on the other side, this was not a case where there was a bona fide contest as to intention. where the Chief Justice had to balance evidence as to coming from both sides as to what the deceased really intended and had to come to a conclusion. So what we submit is that in keeping or in following the reasoning relied upon by the Court of Appeal in Oroso, that when you have clear documentation that speak to intent, in the absence of any reasonable or credible challenge, there is no need, we would submit that there is no need to go beyond that, to find extraneous evidence to decipher the intent. Because you have an agreement between the parties, and as my lords noted earlier, there was the assignment inter se to make this legally effective. And while my learned friend suggests that the term property is somehow confusing or gray or nebulous, we, in our case, prefer to rely on the dictionary definition, the legal dictionary definition of property, which, according to Jowett, which is at paragraph 51 of our case, which is page, no, or you want to take them to the actual, well, the excerpt from Jowett is at page 1265 of the record at volume 2 of the authorities. Where we quote the Lords, this is a different edition, but our quote reads, that property is identified as the highest right a man can have to anything, being that right which one has to lands or tenements, goods or chattels, which does not depend on another's courtesy. Property also signifies a beneficial interest to a right or thing. Now, we submit, my lords, that that is as close to a natural and ordinary interpretation of property as you can get. My learned friend is searching for the word beneficial interest. That is really the crux of his argument, that the absence of that specific term somehow renders any other clause ineffective or not fit for purpose. But we submit, my lords, that the interpretation put on it by a reasonable man is the interpretation that ought to be ascribed to the words as read. So we submit, my lords, that the clause in question is, as the Court of Appeal found them, pellucidly clear, and that in the circumstances the Court of Appeal was justified in taking the position that they did. And furthermore, although His Lordship acknowledged, the Chief Justice, the trial judge acknowledged that it was incumbent upon him to consider the clause, he did not conduct a judicial examination of the clause in the manner of the authorities he himself relied on. He did not come to a determination. He didn't examine the text. He didn't give us anything that would say that he found this to be ineffective for these reasons. There's cursory mentions of things, but no real exposition as compared to his authorities. He relies on Reed Northall, for example, whereas we demonstrate in Reed Northall in our submissions, although the court in that case did disregard the evidence of the banking documents in the circumstances, it was because in that case no one gave evidence of the fact that the banking documents were brought to the court's attention. And the court specifically noted in Reed Northall that the son was there but did not give the evidence that it was brought to his mother's attention, which is in contrast to this case where you have Mr. Moree's, again, unchallenged and uncontroverted evidence that the clause was brought to the deceased's attention. And you have the evidence, I think it's in in Marsden, where the court determined that the evidence of the claimant as to the fact that the account was brought to the attention of the deceased is relevant evidence. However, in that case, the court went on to discount that evidence because there were credibility issues that were explicitly found on the record. And that is why we say that we can't, although the court determined to accord the weight of the evidence of the respondent, little weight rather, in the absence of a finding as to credibility, that particular finding we submit is unhelpful. And we say that regardless of the relative weight, the volume of evidence and the preponderance of evidence on the side demonstrating that the deceased intended to make this gift is overwhelming, particularly in the face that there was no evidence as to intention led by the other side.
You've said that a few times now.
Indeed, that's a thesis statement. So we submit, my lords, that counsel for the appellants have yet to demonstrate a failure on the part of the Court of Appeal in their handling of the Chief Justice's decision. It was within their jurisdiction to find, as they did, that his conclusion on the evidence, on the facts, was one that no reasonable tribunal could come to. And more importantly, they found that it was not supported by the evidence. And in conducting the rehearing that they are statutorily mandated to conduct, that was within their legitimate exercise of their jurisdiction, and the authorities relied upon by the appellants speak to cases that are in no way on all fours with the present case, factually or evidentially. Okay?
Right,
Unless I can be of any further assistance, my lords.
Could I just mention, they've circulated the judgment in Niles and Lake, but I think it's probably not the Supreme Court judgment, so it may not be.
Pardon?
We've just had circulated, but I think it's probably not the one we need, which is the Supreme Court. So I'm sorry about that. It would be helpful to get the Supreme Court one, as we said earlier on, but
Well, was there
Did this go to the Supreme Court?
Was there a Supreme Court
well, it's
decision?
the reference.
There is a different reference in some.
Yes, the reference was to SCR in the Nile and Lake. It's 1947 SCR on page 1135 of the record.
Yeah.
I assume it's the Supreme Court.
Do we know whether the...
Yes.
Yeah. Do we know whether the decision of the Supreme Court was to allow or dismiss the appeal even?
Well, that would be helpful. I mean, what struck me about that was the clause does talk about survivorship, which I think is quite helpful, but...
Yes, it was reversed, my lord.
It was reversed.
The Supreme Court reversed
Right.
the
I see,
judgment
so it's quite relevant.
and restored the judgment at first instance.
Well, somebody has presented us with the
Yes, that
Court
was...
of Appeal decision, which is not very helpful in the circumstances.
No. But it,
Sorry, my lord.
no, it's not your fault, it's my fault. But it does certainly show that we do need to see what the Supreme Court said,
Yes,
because it is a clause which is relatively similar to this one.
yes, indeed, my lord.
So we can...
Mr. Parker,
Yes, my lady.
you've completed your
Yes, my lady.
submissions, have you not? Thank you very much indeed.
Thank you, my lords.
Ms. Quant, do you follow? Mr. Keeley.
My lady, in answer to one of your questions
Now,
earlier,
I misled you about something that I said earlier about the relationship between Pecor and Madsen, because you were right to say that Justice Abella dissented in Madsen, but you were wrong to say that she dissented in Pecor. She reached the same result for different reasons in Pecor, but that was as between the husband and wife. And as between the husband and wife, the Supreme Court found in favour of the wife. But as between the wife and the siblings, the Supreme Court found in favour of basically the siblings, well, the estate. And Justice Abella dissented because she's still applying the presumption of advancement.
Was
But
it-
she's consistent.
It's a fluke that I got it right, my lady.
You didn't get it right because you said she dissented in Pecor. But you were right that she had dissented in related proceedings.
I had thought she had, but I obviously
So here am
hadn't
I
picked everything
apologising
up.
to you for having misled you.
My lady, in terms of procedure, the rule is that if there is no specific Bahamian provision, the English rules of procedure apply. But there is nothing in relation to substantive law in the Bahamas. There is no rule in the Bahamas that if there isn't a special legal principle under Bahamian law, it is the English rules or principles that apply. And that's probably an explanation. I mean, I know that we in England refer to a lot of Commonwealth jurisdiction judgments, but it's probably why in the Bahamas there is particular reference to a broader range of judgments than perhaps we have here. Secondly, my lady, you asked me about the right of survivorship, and I knew I'd seen something in the papers on that. If your ladyship could go to the judgment at paragraph 18, which is at page 94. And you look at the quotation from the Ontario Superior Court of Justice in Sordon Estate. And my lady, my lords, that is to be found in the authorities bundle at divider 13. It begins at 825, but this passage is at page 847. And it's the last paragraph. The opening of a joint account gives each account holder a legal interest in the monies credited to the account at any one time, and the right of survivorship arises by operation of law as part of the legal concept of joint tenancy. And just pausing there, my lady, as I understand it, the right of survivorship is an incident of a joint tenancy. It arises by operation of law, and therefore whether you say that in a contractual document such as a bank document or not, it makes no difference, because that is the result of a joint tenancy. The joint tenancy, of course, doesn't answer the question as to what is the estate or the interest which is held by the joint tenants, and whether it is a legal estate or interest holding on trust for somebody else is not part of the equation. And I do apologize about the Niles case, because obviously it is an important case, but I say no more than that if that passage, which one sees in the Court of Appeal, is right, and one has no reason, at least I have no reason at the moment to doubt it, without having looked at the Supreme Court's decision, then, and that's at page 128 of the bundle, then there are two comments that I would make, my lady. And the first comment is that if that is right, then the Court of Appeal could not reasonably have come to the conclusion to which it came, which was that the terms of the bank documents in our case were, as they put it, pellucidly clear. Or if they were pellucidly clear, they were certainly pellucidly clear in my favour, rather than pellucidly clear in favour of Mr. Moree, saying that he took a beneficial interest by virtue of Clause 20. Pellucidly clear are the words to be found, my lady, my lords, at paragraph 50, at page 133 of the bundle. And if I could, just to make good one or two points made earlier, if you go to the particular clause in question at 088, that's 88 of the bundle, and one takes into account the Niles decision. In my respectful submission, I was right, and therefore I'll only say it one more time, because otherwise I'll bore you. The first sentence does not make it pellucidly clear. In fact, the first sentence does not refer to the beneficial interest in the property. It is confined to the legal interest in the property. The second sentence simply explains the first and explains the right of survivorship, to which I've just taken, my lords and my lady, which is an incident of the joint tenancy referred to above. And thirdly, the assignment does no more than give effect to the antecedent two provisions. It doesn't add any further transfer. Therefore, I revert to my original submission, which is that these banking documents may be taken into account, as indeed the Chief Justice did, in determining actual intention, but are by no means conclusive, and if they are to be given any further weight than that which the Chief Justice gave, that entire weight is to be accorded to my clients rather than to Mr. Moree. Because if they are clear, they clearly do not gift the beneficial interest in the monies to Mr. Moree. Going back to certain details referred to by my learned friend, firstly, in relation to the oath, my Lord Wilson kindly drew our attention to passages in the cross-examination and referred, I think, to 266. The passages go from 264, 266, 267, 270, 271, and 272. It is fair to say that the evidence of Mr. Moree was entirely unsatisfactory in relation to the oath and in relation to the schedules attached to the oath. I should mention that Mr. Pinder was himself cross-examined on this, and Mr. Pinder's evidence will be found at page 242. And at page 242, at lines 7 to 14. It's not very extensive, no doubt, rightly so. Mr. Moree went with you to the registry to swear that oath, right? And both of you swore the contents of the oath to the schedules that were exhibited. It was all there. I'm so sorry, this is examination in chief. It was all there, yes. And Mr. Moree swore the oath with you. I think so, yes. And if you go on to the cross-examination, to page 247, Mr. Parker cross-examined at line 21, you prepared the schedule to the oath based on what Mr. Moree told you, yes, and therefore you're not in a position to refute Mr. Moree's statement that it is incorrect to list the $190,000 as an asset of the estate. You have no answer. I have no evidence other than what Mr. Moree told me, yes. So when I put it to you that, in fact, this money is actually Mr. Moree's and that it was put in by mistake, you can't challenge that, can you? Answer, no. But that is as far as it went, my lady, my lords. This was a point which was not addressed, the oath and the schedule were not addressed by the Court of Appeal. And it's no answer, in my respectful submission, to suggest, as my learned friend did, well, that's because of the earlier dissipation of all the assets in the accounts by Mr. Moree. The fact that he might have dissipated all the assets does not answer what he was saying about the oath and the schedule, and doesn't explain why the Court of Appeal did not deal with this. In relation to the oath and the schedule, my lady, Lady Hale, referred to the document. And if I could just take you to it, it's at page 175, 176, but it also includes 177.
Yep.
I should say, while you're looking for that, $350,000, or for that matter, $349,000, have no relevance to any probate fee at all, and there is no inheritance tax in the Commonwealth of the Bahamas.
Thank you. It's just my suspicious mind, you see.
It's lucky them, anyway. But if you go to the oath, what you will see that this is obviously, as I think my Lord Carnwath mentioned, confined to the Bahamian assets as opposed to assets in England and places like that. And actually the property, the real property, is dealt with at 177. So while the oath is at 175 and deals with real and personal property, 176 covers the personal and 177 covers the real. So in fact the property is included in the schedules to the oath.
The property is included in the schedules, but it's not included in the statement of the total being less than 350,000.
That is absolutely
That was the only point
I'm
that
so
I was
sorry.
making.
I'm so sorry. That's probably because...
I had read the whole document.
I'm so sorry, my
lady,
lady, but that's probably because the title at 176 is personal estate, whereas the title to 177 is real property. And therefore,
That's just 176, but on the front page where it gives the total, it refers to all property.
Does it?
It says the personal estate and effects. And that, my lady, is a reference to 176.
No, the whole of the
No.
property, to the best of our knowledge, information and belief, the whole of the property of the said deceased, to be affected by the grant applied for, is comprised or referred to in the schedules possessed, and the personal estate and effects are under the value. Yes, no, that's fine. Yep. Good, sorted that out.
Not very clear.
But I was a bit worried to begin with.
Yeah, yeah.
Secondly, in relation to the meeting with Mr. Pinder, this is the 31st of March meeting, if I might respectfully say so, Mr. Moree's evidence in relation to that was equally unsatisfactory. You know about the meeting. Mr. Pinder took a contemporaneous manuscript note. You'll find that at page 203. And at 203, what you will find is, in Mr. Pinder's handwriting, a list of what he was told by Mr. Moree. And as you know, from page 243 in the cross-examination, Mr. Pinder did not know anything about the accounts at the bank before his meeting with Mr. Moree. So this is all new information. And you'll find at item 2 the 2 accounts. And that's what the schedules to the oath were based on.
Was this before or after he had put it in his name of his wife?
This was after he had put it in the name of his wife. So your lordship's absolutely right. It may be thought to be inconsistent with that, but on the other hand, not necessarily. It depends whether, having put his wife's name on the account, he was actually saying to himself, I'm entitled to these monies and entitled, therefore, to the beneficial interest.
Yes, I mean, your point, it's that Mr. Pinder had no reason not to take down what he was told by Mr. Moree. And
Exactly.
had Mr. Moree said, oh, well, that's my money, not the estate, he would have noted it.
Well, Mr. Pinder, as he said in his evidence, arranged the meeting in order to ascertain the assets of the estate. That's in his first witness, in his first affidavit, which I'll tell you where the reference to that is in a minute.
Well, it's at 200, isn't it?
There are 2, my lord. There's one at 200, and I think there's an earlier one as well. Mr. Goodcamp will probably tell me where that is if I haven't overlooked it. But I'll come back to that in a minute. But of course, if indeed, as Mr. Moree says, he thought he owned everything, why on earth did he even mention the account, one might say? Why did he mention the account to Mr. Pinder, who after all was only, his only status was as an executor of the estate to administer the estate? Now, I'm not saying that there couldn't have been a misunderstanding. Of course there could be a misunderstanding. But what one does note in all this is that certainly Mr. Moree was not so generous as to think that there was just a misunderstanding. Because, of course, Mr. Moree gave evidence, as you know. If you could look at page 184 of the bundle.
But what does Mr. Moree's understanding or intention have to do with it? I mean, it's not suggested that there'd been any discussion on this subject between Mr. Moree and the deceased. We're only concerned with the deceased's intention so far as resulting trust comes into the picture.
You're right, my lord, but what Mr. Moree said in his affidavit evidence is that it was our understanding that the monies in the account were beneficially owned by Mr. Leonard and Mr. Moree, and therefore...
That seems a statement of the conclusion rather than the reasons for it.
Indeed, but then when he comes along and says to his fellow executor, possibly, according to this note, these are assets of the estate, then that would indicate that their understanding at the time of opening the account, or rather converting the accounts, was quite contrary to that which Mr. Moree was postulating or suggesting. That's the relevance. If you go to this evidence at 184, and I should say that Mr. Pinder was cross-examined on this and he denied this. At paragraph 7, I think Mr. Parker, in fact, almost reiterated the suggestion that there was a failure of due diligence on the part of the hapless Mr. Pinder. But at paragraph 8, I advised my co-executor, Mr. Pinder, from the very beginning that the account was mine. I even provided him with copies of the bank forms showing that the account was, as of the 11th of March, held by myself jointly with my wife. He's continued to use it, etc. And in paragraph 9, I received word from my co-executor, the plaintiffs were raising questions, suggesting the funds on my account were assets of the deceased estate, which was untrue to his knowledge and demonstrably false otherwise. This is why I should mention to you, this is why so much attention was placed at the hearing on the exchanges or interconnections between Mr. Pinder and Mr. Moree. It's because these allegations were made and they had to be dealt with. And I say it without, not because it is a forensic point, but simply because it is a real point, which is that the allegation against Mr. Pinder was essentially, as one alternative, one of fraud. And they were demonstrably false. But that's just by the way. My Lord Sumption put it to my learned friend that when the judge said that Mr. Moree's evidence was self-serving, that really meant that he found it unreliable. That's, in my submission, right. Can I just give you a reference to the case of Thompson? It's in divider 5 of the authorities. It's at page 2, at the page 700. And it's to the speech, I think it is, of, or the judgment of Lord Hope.
Wait, which divider again?
It's divider 5, my lord, and it's the, this is in the House of Lords, so it's the speech of Lord Hope. And it's the passage at paragraph 20, which is worth looking at. This was the Lord Aundry, so it was an appeal from Scotland. The question to which he addressed his mind was whether the account which the respondent gave was to be rejected as unreliable. But the fact that reliability, not credibility, was the issue doesn't mean that an appellate court is in as good a position to resolve it as the trial judge. And then if you go on with that, I won't read it out because of the time, the last couple of lines, an appellate court should be slow to interfere with a decision based on a view of the reliability of witnesses of whom the Lord Ordinary was able to make a personal assessment. And that is our case, my lords and my lady. My learned friend criticised my clients for not themselves leading evidence as to the intention of the testator. Now, in my respectful submission, that's a surprising suggestion, because the way in which the case was run was on the basis that there was a resulting trust, which was accepted by both parties, so that the burden of proof lay upon Mr. Moree. It wasn't my client's burden to satisfy, it was that of Mr. Moree. Of course, if my clients had positive evidence, no doubt they would have led it. But the criticism of Mr. Moree and the absence of objective, dispassionate, independent evidence comes in the judgment at paragraph 22. If you could go to the judgment at paragraph 22, something with which, of course, you're already very familiar, it's at page 96. after having essentially said that Mr. Moree's evidence was unreliable. He says about 5-6 lines down, as I observed earlier, no evidence was adduced from the bank officer who was present when Mr. Moree was made a joint owner of the account. That officer may have given evidence as to what was discussed at the time of the transaction, in particular why the words to pay utilities were written on the form. Mr. Moree's evidence of Mr. Leonard's intention is not supported by any statements by or correspondence from Mr. Leonard to other persons of his intention, etc. And then I think there is also a passage, and I'll get it in a minute, it's that there is a passage that there was also no evidence. It is at paragraph 29, my lady, my lords, page 99. The fourth line, the officer of the bank who prepared the forms was not called to give evidence of the usual procedure regarding whether his usual duties encompass explaining the form before the account holder signs the agreement. And therefore, not just on the basis of that sole fact, but on the basis of all the circumstances, the learned Chief Justice drew the inference of fact, which was the critical inference in the case. And so I come back in the last few minutes. I just want to deal with pleading and costs, my lady, if I could have an extra minute.
Well, you've already had more than you intended for by way of reply, and
Right.
it is 1 o'clock.
Right, well then I will say nothing more about the pleadings, etc., other than that the learned Chief Justice, when he made his judgment and decided that the monies were held on trust for the estate, of course, he couldn't decide what the executors to the estate should do in relation to the administration of the monies, and it was sufficient, therefore, for his judgment that he should hold that the monies were on trust for the estate so that the executors could then administer those monies in accordance with the will. It was not
Indeed, that wasn't what the claimants were claiming.
It wasn't directly what the claimants were claiming. I should mention, however, it's what I'm basically saying the Chief Justice was right about, however, and therefore I'm endorsing the Chief Justice's decision.
I was looking for an order from the Chief Justice.
Well, the reason why there was no order, as I'm instructed, my lady, was because when they returned to the Chief Justice following his judgment and sought an order, the Chief Justice recommended and directed that they should go and try and compromise.
To cut things short, there was correspondence about this. It's in the bundle. When can we have a meeting to do what the Chief Justice has said, namely draw the order? And all that was overtaken by the presentation of an appeal. That's
right, my lord, yes. And that's why there was no order as to cost. That's why there was no application.
Technically, you can't have an appeal if there isn't an order to appeal against.
In the Bahamas, I don't know what the position is, my lord.
I'm surprised if it was any different, but maybe it doesn't matter.
Well, as far as costs in this before the board are concerned, we normally either ask for submissions about costs after we have expressed our opinion, because that's all we can do, or we express a prima facie conclusion on the matter of costs and then invite anybody who disagrees with that to put in submissions within a certain amount of time. It depends.
Sorry,
Yeah.
Niles and Lake, I'm sorry, I've now got the Supreme Court version. I think it is going to be of relevance, and so it would be helpful to have some sort of arrangement for us to deal with that.
You've got the Supreme Court.
Well,
You've got it on your screen.
I've got it on my screen. I decided not to try again to get copies, which seem to misfire, but it clearly is a relevant authority.
Well, it looks as if it's relevant, although it may be overtaken by subsequent Supreme Court of Canada, in fact is, approach to things. But it would be of benefit to have copies, and perhaps you would supply them, please.
Certainly, my lady. Would your ladyship like me to, I don't invite this, like any written submissions confined to 1 page or 2 pages, or would your ladyship take it on?
I think we would, speaking for myself, I would prefer just to read it and draw my own conclusions.
That's a relief to me, my lady.
It's also the cheaper option. We're grateful to you all for your submissions, both in writing and orally, and for those who've assisted you with those, not just those of you who've been on your feet. We will take time to consider what advice we will humbly offer to Her Majesty and let you know what it is in the usual way. Board is now adjourned.